right, going to call to order a regular meeting of the Planning Commission. Phyllis, roll call.
Chairperson Bob McCool.
Here.
Vice Chairperson Lisa Ritchie. Commissioner Phyllis Harden here. David Harper. Here. Jerry Malia. Here. Ben Miller.
Here.
Jason Reese.
Here.
Anthony Stewart. Steve Whitty. Planner Stephen Williams.
Here.
Attorney Dan Harvey absent. Okay.
All right, we have time for public comment on any consent agenda or non-agenda items. See that there are none. Go on. We have a chairperson, vice chairperson election, but only 2 accepted nominations. So what do we do?
I would just vote. I think they have to be individual votes on the chair and then the vice chair. So just take vote on each.
All right.
And then
All
we'll move on.
Take a vote on both vice chair for Lisa. All in favor? Okay, that's unanimous. Vote for chairperson. I guess I'll keep doing. All in favor? That's fine.
Perfect.
Thank you, Chairman Nicole.
Yes, thank you. You're welcome. Sure. All right, consent agenda. We have minutes from January 7th. I'll entertain a motion if somebody would be so moved to do that.
I'd like to make a motion to approve the minutes from the previous meeting.
All right, we have a motion from Commissioner Malia.
Second.
And a second.
I was absent.
Oh, and 1 absent. Okay. All in favor? 2, 3, 4. It's unanimous. 1 abstention. Okay. Let's talk oil and gas.
All right. We have Matt Sura, the town's special counsel, here tonight to discuss the proposed oil and gas regulation changes to our code. And he's got a pretty thorough presentation, so I'll turn it over to him. And you guys, this is a discussion item. We're not, passing a resolution or anything on this, but the board will act on this on March 9th. So.
Great. Thank you. It's a pleasure to be here in Superior once again. Is this something that's visible, or
yeah,
is there?
She'll turn that off.
Okay. Yeah. Sure. My name is Matt Sura. I'm special counsel to the town of Superior on oil and gas matters. I've been working with the town of Superior. I just found out for about 16 months is all. I've got a brief presentation. Maybe it's not so brief. I felt like I wanted to just go through a little bit of the last 16 months and to give us all an idea of how we got here in such a short time. Things have changed dramatically. So I'm going to give a little bit of background, talk specifically about the revisions to the municipal code that we're proposing to do an ordinance, and proposed resolution that would be the best management practices for the town of Superior if and when oil and gas development were to occur. So background, how did we get here? Town of Superior is in blue. You knew that. This is from the Colorado Oil and Gas Conservation Commission map, and everything that you see in yellow is a municipality. So you've got Broomfield here, you've got Thornton, Erie, Boulder, of course, and you know and have heard about the controversial oil and gas development that is in Broomfield along the E470 corridor. And that's what you're seeing here. Every one of these wells is drilled approximately 7,000 feet below the surface. That's where the Niobrara or the Codell oil and gas bearing formation lies. And once they get to that 7,000 feet below the surface, they turn that drill bit and they can go out as far as 3 feet. So you can see here, this is going, these are each a section. Yeah. This is going half foot, mile and a half, 2.5 miles. Now, are you going to give me a pointer?
Yeah,
That's
just
a
so we
great
can
idea.
still hear you.
I appreciate that. Thank you. Okay, excellent. So the colors. Important to know what you're looking at. Everything that is in purple has been drilled. Everything that is in green has been approved by the Colorado Oil and Gas Conservation Commission, but has not yet been drilled. And then everything in light blue is proposed, but has not yet been approved by the Colorado Oil and Gas Conservation Commission.
Sorry, did you say everything in purple has been drilled?
That's correct.
And also,
Well, except for the town of Superior.
Oh, that's blue, sorry.
Yeah.
It's supposed to be blue.
He's
I'm talking about
the
these lines, the horizontal lines.
Yeah.
and I'm sorry, I heard you say 7,000 feet down and then they turn and
We
I
can go
heard
how
you say 3 feet, but is it 3 miles?
Three
or-
3 miles. So
3 miles.
every one of these
Okay.
is a
I
section.
heard 3 feet too.
Okay.
Did I say feet?
Yeah.
Yeah.
That's
No
not
worries.
very long.
We- That's awesome.
Yeah.
It's a lot of wells.
So it's, it goes out, half a mile, mile and a half, and then 2.5 miles. So, that's one example. This is a 3 mile lateral is what it would be called.
Is there any
So
regulation around that horizontal, how far they can go once they're down there, or?
It's really not in regulation, it's technology. They have to have enough, basically, weight to be able to push that drill bit, 3 miles. And 3 miles is about what they've been able to do. They don't feel confident that they can go farther than that, but technology is always improving.
Sure.
The point being is that they have a lot of capability of finding good locations. They don't necessarily have to be on top of the resource that they're extracting. They can be as far as 3 miles away and get to that resource. So this is what started it all in November of 2018, whereas development proposed by Highlands Natural Resources. And Highlands Natural Resources is a small company that didn't have much of a track record, didn't have many wells that they had drilled. And we're proposing a number of locations, including one location within the town limits. The other ones, if that wasn't bad enough, they're also proposing to drill through Rocky Flats and underneath Stanley Reservoir.
I apologize, but could you tell me what the red dots are?
Yeah, I can. And I'm going to go back and show you more of those. Every one of those red dots is a location, an oil and gas location. It could be a current oil and gas well, or a plugged and abandoned oil and gas well, or even an abandoned location where they never actually drilled, but it was an approved location through the Colorado Gas Conservation Commission. If we were to pull back, and I think I do have something that's going to show this in a bit, you would see that there are about 55,000 active oil and gas wells in the state of Colorado, and majority of those are located on the Front Range in what is called the Greater Wattenberg Field or the Denver-Julesburg Basin. Again, this is just another picture, and you can pull all this up on the Colorado Gas Conservation Commission. They were proposing within the town limits 31 wells, 62 tanks, a huge amount of tank battery, 31 separators, and emission control units, which are flares that are burning off some excess gas. Superior Code at the time wasn't equipped to handle an application, an oil and gas application of this magnitude, certainly not with the directional drilling and the multi-well facility that was being proposed. As most local governments did at the time, you allowed oil and gas development through your code, through a special use permit, and it was allowed in agricultural and open space districts. They had to make sure that they were not going to materially endanger the public health or safety or injure adjoining or abutting property, be in harmony with the area. It was more or less a general special use permit process and criteria. And the reason that Superior and so many of these local governments had really allowed for oil and gas development is because they didn't have an option. Preemption law that was particularly decided through Voss versus Lenval back in 1992, but also more recently in the Longmont case, in the Fort Collins case, found that local governments did not have the ability to go beyond the Colorado Oil and Gas Conservation Commission with their regulations. Colorado Oil and Gas Conservation Commission being the state agency that regulates oil and gas under the Department of Natural Resources, they really called the shots. And it was very difficult, if not impossible. Certainly you would be in trouble legally if you tried to go well beyond the Colorado Oil and Gas Conservation Commission. In fact, just before in the beginning of 2019, the city of Thornton did lose a preemption lawsuit. They tried to go from the 500-foot setback, that is an oil and gas facility, can't be any closer than 500 feet from a home. And Thornton said, you know, we want to make that 500-foot setback 750 feet. And they lost that lawsuit because of preemption. There's also this case that came up just in January of 2019, the Colorado Oil and Gas Conservation Commission versus Martinez case. And what the Colorado Supreme Court found is that the Colorado Oil and Gas Conservation Commission's mission is to foster the development of oil and gas resources and to protect public health, safety, and welfare, but only after taking cost effectiveness and technical feasibility into consideration. They can protect public health and safety only if it's technically feasible or cost effective for the industry. That was the decision. Obviously, this alarmed a lot of people. Local government's very concerned because they've been told that they're hamstrung, that they have to follow the Colorado Oil and Gas Conservation Commission, and now the Supreme Court is saying Colorado Oil and Gas Conservation Commission is not going to be protecting public health and safety. They may be protecting public health and safety, but only after fostering or promoting the oil and gas industry. Political change came, and it was not only through the election of this gentleman, Governor Jared Polis, but also Senate Bill 181 was signed into law in April 16th, 2019, really changing the way that oil and gas is regulated in the state of Colorado, both at the state level and at the local government level. So it reforms the Colorado Oil and Gas Conservation Commission. It's now their sole mission to protect public health and safety. Fostering the oil and gas industry is no longer part of their mission. And it gives local governments such as the town of Superior clear regulatory authority over oil and gas, ending forever state preemption. You now have the ability to go beyond the Colorado Oil and Gas Conservation Commission. Colorado Oil and Gas Conservation Commission, the state regulations are a floor which you can go above. Local government regulations, however, there were some sideboards, and your local regulations must be reasonable and necessary to protect public health, safety, and welfare. It gives you clear authority for the location and siting, and including using your authority for zoning, mitigation of impacts, financial issues, making sure that the oil and gas industry and the regulation of the oil and gas industry isn't costing your taxpayers, and the power to enforce your regulations. The first out of the gate was Adams County. You're our neighbor to the east. Adams County prohibits oil and gas development within residentially zoned areas. That was unheard of. They also prohibited oil and gas development within 1,000 feet of residential lots. Now remember, the Colorado Oil and Gas Conservation Commission allowed it as close as 500 feet from the actual home, the side of the building. Had to be a home there, and it was 500 feet from the building to the actual wellhead or tank battery. Now, they are looking at oil and gas development has to be 1,000 feet, double that, from a residential lot, whether it's built or not. So protecting future development. Requires an alternative location analysis. Again, if they get anywhere near homes, they say, look, you know, you have all this flexibility with this technology that you have, you know, to drill 3-mile laterals. Let's look at some other options. If it's too close to a residential area, or if it's within a floodplain, as an example. And requiring greater air quality protections. And air quality protections are important because, as was discovered in October 2019, Colorado Department of Public Health and Environment came up with a study, and they said, you know, through the modeling that they did, taking samples from sampling in 2014 and 2015 in both Weld County to the north and in Garfield County on the western slope, they found that their modeling showed that there could be real impacts, short-term acute impacts to public health. Colorado Oil and Gas Conservation Commission reacted by saying, you know what, we are going to immediately put some additional protections in place, and we're going to require additional review anytime an oil and gas facility is proposed within 2,000 feet of a home. Doesn't say that they're going to say no. It's just saying, look, we're going to make sure that, you know, you're using some best management practices, and that, you know, it's not going to cause harm to that population. Also, they're doing some additional research right now. They're spending over $1 million to take additional samples throughout Colorado at all different stages of development, of oil and gas development. And they're using that new research to inform new rulemaking. That rulemaking is required to be complete, mission change rulemaking, they're calling it, by July 1st of this year. So the proposed changes to Superior's regulations include changes to process, location using zoning, and allowing for a location waiver if necessary and they meet the requirements. Also requiring greater mitigation of impacts, best management practices, and addressing financial issues. So first, we've got a permit required. We're calling it an oil and gas permit. And it requires an oil and gas permit for modifications of facilities, amendment to an oil and gas permit, or plugging and abandonment. There's also going to be a provision for seismic permits and pipeline permits, and those seismic permits and pipeline permits are at this point considered administrative. Also looking at the term of the permit being 2 years, can be extended by the town manager. There's going to be an application fee that is going to be by fee resolution, a cost reimbursement agreement, meaning that if you decide to hire someone, an expert in oil and gas to review the permit application, that's not going to be on taxpayers' dime, that's going to be on the industry's dime. Financial assurance of $3 million, and that's specifically for an event where they go out of business in the middle of drilling and completion, in which case $3 million is more than enough, more than sufficient to be able to plug and abandon all of those wells. I don't even expect that would be the case if somebody went out of business. It would likely be taken over by either the Colorado Oil and Gas Conservation Commission or another operator. But worst case scenario, you have $3 million in which to do that. Inspection fees are going to be paid for by the industry and a road improvement and maintenance agreement. Lots of plans. This application is typically something that takes months for the applicant, and this is something that they're used to now. All of the applications that they're doing in Adams County, all the applications that they've done in Brighton and smaller towns include all of these components. Traffic control, emergency response, weed control, dust mitigation, wetlands protection, electrification, site security, and the rest. The process for review is very similar to a special use permit, conditional use permit. There's a pre-application conference where they sit down and say, the operator says, this is what we're trying to accomplish. Can we find a location within the town of Superior in which to do this oil and gas development? And the planning staff can look at them and say, you know, that location right there is platted to be residential, probably a terrible location. There might be a better location over here. Have you looked in Jefferson County? You know, looking at different locations, different opportunities for the oil and gas industry to be able to accomplish what they need to. And allowing and requiring them to do an alternative location assessment if they so choose. The application submittal, reviewing for completeness, and the rest. This is a typical application process. Ultimately, a hearing before the Planning Commission and then before the board. Criteria for review, how you would judge an oil and gas application would be that all the application requirements are met, that complies with location restrictions, which we're going to get into in a minute, and complies with the provisions and practices in the BMP document, and also all the approval criteria in section 163480, which is your areas of activity of statewide interest. 1041 powers. You're one of the few local governments that I work with that have fully adopted your 1041 powers. What that does is give you the ability to go beyond the state, frankly, in protecting a specific resource or regulating a specific resource. And it particularly calls out oil and gas or minerals. And we're going to make some slight changes to make sure that it calls out specifically oil and gas. Those require additional protections for air quality, visual quality, surface water quality, groundwater, and terrestrial and aquatic, animal and plant life, soils, and recreational opportunities. Recreational opportunities being something that you would regulate and make sure that this is considering those recreation opportunities if it goes forward. Also, it's not going to result in substantial or undue adverse effect on adjacent landowners and conformance with the Town of Superior Comprehensive Plan and significantly degrading the public health, safety, and welfare. Cannot significantly degrade public health, safety, and welfare. Location restrictions are very similar to what has been done in Adams County. We're looking at allowing it in agricultural, heavy industrial, and light industrial areas. Also looking at that same 1,000-foot setback from a parcel, property line of any existing or platted residences, schools, etc., as well as parks. And well sites should not be located or have to be located at least 500 feet from public water supply wells or surface water bodies. So we ran a map to find out just where would be these locations that could potentially be affected. And these are industrial zones here. But if you look at the 1,000-foot setback, those areas, are going to be difficult to develop because they are, frankly, less than 500 feet, most of them, from residences, and certainly less than 1,000 feet. So there's an opportunity for a waiver. It's similar to a variance, although the criteria is a bit different. Location satisfies all the other criteria for review. There are extraordinary hardships or practical difficulties, and protection of public health, safety, and welfare are served to a greater extent by a waiver than by strict adherence to the setbacks.
If they can go 3 miles horizontally, what would be the basis for a location waiver within 1,000 feet?
That is a very good question. Unlike the city of Thornton, unlike Commerce City, most every other city, there would be, if you were to restrict oil and gas access from residential areas, it would be very difficult to reach those minerals underneath the middle of the city of Thornton, because the town is more than 6 miles across. This town is less than 6 miles across, can be reached, every square inch of your minerals can be accessed outside of the town boundaries. And I would argue that, in just looking at a map, and I haven't studied this and we haven't talked to the planner or anything, I would argue that there are locations, safe locations from which to drill Town of Superior minerals, but well outside the city boundaries. So I'm going to pause there and just see if there's anything that you'd like to ask about the proposed code revisions. And this is kind of part and parcel. This is more like the mitigations for oil and gas activity that is approved.
I guess the only thing I'm wondering is this only applies to well sites, right? So as long as the well site is outside of the town, none of the resolution wouldn't affect anything. Is that correct?
Yeah, that's a great question. It is actually all oil and gas locations. So if there was a production facility, say that it was a tank battery, where there was an oil and gas well location outside, but they wanted to have a tank battery for some reason inside the town, it would also apply there. Compression engines. If there was a gas compression engine that they wanted to put within the town boundaries, it would also apply to that.
Or a pipeline. I think you mentioned a pipeline too. If they wanted
So
to.
pipelines are a different issue. Pipelines can be done safely in every district. And, you know, there need to be setbacks, appropriate setbacks from homes, from other areas that are used by human beings. But every one of us has, I'm guessing, has a gas pipeline coming into their home. And gas pipelines, oil pipelines are frankly very safe. And I would argue that oil pipelines are far safer than having a tank battery of oil and constant truck traffic, those tanker trucks coming and going and taking that oil away from the site. I would much prefer to have an oil pipeline than a tank battery for a number of reasons, including air quality. Those tank batteries are the worst polluter from the oil and gas industry. They're designed to breathe, and some of the odors that we smell from the oil and gas industry are volatile organic compounds, something that can be dangerous to public health.
So, sir, one more question for you.
Sure.
So everybody up here, I think, is a property owner in the town of Superior. I don't know where you live, Stephen, but none of us own the mineral rights to the subsurface of our properties. We all have surface rights, correct?
I
mean, more than
wouldn't
likely, I
even
mean,
be able
you
to hazard a guess.
yeah.
You
And
know,
so-
typically it's about 50% of the folks that I work with own their mineral rights. And they could have been separated for any number of reasons, going from the beginning of statehood, frankly. You know, when the railroads came through, they gave every other section to those railroads as an incentive for them to build those railroads. And ultimately, they sold the surface, but retained those mineral rights. Those mineral rights become the railroad sections, and those all are now owned by Occidental Petroleum, frankly. So every other section near railroads are typically severed minerals. The surface owner does not own those mineral rights. Also, what is typically the case is that in some places where there was a rancher that ended up selling the ranch to development, you know, sometimes they may have withheld those mineral rights.
The rancher.
The developer withheld those mineral rights, sold the surface, but withheld the mineral rights.
Yeah. So then, in practice, they could have wells and sites outside of the town of Superior, but be drilling underneath through the mineral rights and the subsurface of the town of Superior.
Yeah, about 7,000, more than a mile and a quarter beneath the surface.
Okay. Just want to be clear.
Yeah. So best management practices, these best management practices are, I believe, the definition of necessary and reasonable. There are already practices that operators throughout the state have accepted voluntarily because they entered into operator agreements with local governments prior to this preemption getting worked out through Senate Bill 181. Local governments would have to negotiate contracts with operators to try to get greater protections than were offered by the state. And they deal with everything from air quality, water quality, all the rest. Importantly, I think emergency response plans are something that the Colorado Gas Conservation Commission doesn't regulate. That really has been left to local governments, as well as transportation and circulation. But after Senate Bill 181 passed, really all of these are fair game. Anything that's above the surface, below surface is still Colorado Gas Conservation Commission. So you're not going to be able to regulate exactly where those well bores steer or anything below the surface. But if it's happening above the ground where we're all living, that's what you can regulate. So requiring electric equipment instead of having engines out there. Green completions, which means instead of completing into an open pit, it's completing into a tank, dust and odor controls, and other air quality measures. Water quality, chemical disclosure, requiring testing of all available water sources, that is potable domestic water supply wells. They have to test all of them within a half mile, or offer to test all of them within a half a mile. Also, there's a list of prohibited chemicals that the oil and gas industry can use in hydraulic fracturing. And these are those that have been banned by a number of local governments and in a number of operator agreements. Again, looking at closed loop pitless systems, containment berms, pipelines being the most important mitigation, frankly. If there was one thing that you could do to prevent adverse impacts to public health and safety and welfare, if it had to be located anywhere near your community, requiring pipelines is the most important mitigation measure that you could ask for. Noise mitigation. Right now, the Colorado Gas Conservation Commission allows for the act of drilling and completion, that is the hydraulic fracturing that they do, which is very noisy, can be very noisy. They allow that to exceed 75 decibels, even 80 decibels. And that's industrial level noise. What we have here is a 55 decibel limit, or 4 decibels over the baseline ambient sound. So keeping it, it's going to be anywhere near the town of Superior, it's going to be at levels that are residential noise levels. Traffic control plans, looking at pipelines, visual mitigation. Again, this is landscaping, the kind of things that you would have for any development within the municipality. Community outreach, making sure that they are not only reaching out to those who are impacted by their development, but also coming to the town trustees twice a year, giving updates as to how their facilities are going until it gets into production phase, in which case those annual updates are suspended. Requiring final reclamation, and that's the end of my presentation.
Thank you.
Thank you.
Do you have anything to add, Steve?
I don't think so. You guys have any questions for me or for Matt?
I know Lisa has her set of questions here. I can,
Okay, you want to go through those?
maybe we can work through those. I didn't quite follow her first one, but is the rulemaking complete following passage of SB 181? And if not, should we wait until this is complete and extend the moratorium?
I can address that.
Okay.
So Senate Bill 181 did require a lot of changes of the Colorado Gas Conservation Commission, and specifically set out a number of rulemakings that have to occur before July 1st, 2020. July 1st, 2020 is when there's going to be a new Colorado Gas Conservation Commission seated, professional commission. Right now we have a 9-member commission, and they have all sorts of varied interests and come from different parts of the state, and that's all part of the state statute. Well, that part of the statute is going to be kind of sunset, and then there's going to be this new commission that is seated, much like the Public Utilities Commission, that is a paid professional commission that is also going to have varied degree of backgrounds, but they're going to be working full time. So one of the rulemakings, probably now it's the major rulemaking, is called the mission change rulemaking. And that is, again, taking out the requirement that the Colorado Gas Conservation Commission foster the oil and gas industry and then protect public health, safety, and welfare if it's, if they can financially, feasibly do it. This is taking off all that fostering or promoting oil and gas development and just re-regulating oil and gas to protect public health, safety, and welfare. And that's going to look very different. We've got new CDPHE studies. I put in a number of studies in the record, health-related issues. You know, and so I think the Common Gas Conservation Commission staff and the commission members, until July 1st when they leave, are taking it very seriously, and it's going to be a long, probably a 6-week rulemaking that is going to start in probably May and conclude in June.
So then her question was, should we wait until that's complete and extend our moratorium versus putting this into place?
So one of the things that the proposed regulations state is that they still have to comply with state law. And so if state law ends up being somehow more protective or less protective, you know, they're going to have to follow the most protective standard, whether that comes from the state or from the code. And so, yeah, if they decide to go with say a 1,500-foot setback, and you've got a 1,000-foot setback, then the setback is going to be 1,500 feet. And you can go ahead and change it in your code if you like, but no one can come to you and say, you know, we're going to do a 1,000-foot setback if the state is requiring 1,500. Again, it's going to be the more strict standard is going to automatically apply. So I don't think that there's a need to continue the moratorium at this point. I think that these regulations are protected.
Let's see, she said other communities are including additional submittal requirements regarding past performance, the ability to reliably operate. This could include the following types of information. She listed a bullet list of stuff, which I'll hit, and she asked, should we consider additional information to determine this, or do we trust that the COGCC will vet these through their permit process? I'll read through the one she brought up. Based on the operator's business plan as of the date of registration, a good faith estimate of the number of well sites and wells the operator intends to drill in the next 5 years within a city. Publicly traded companies' well estimates may be based on reserves classified as proved undeveloped for SEC reporting purposes. A map showing within the city of any sites for which the operator is approved or has submitted applications for drilling and spacing orders, or COGCC Form 2S or Forms 2As, and sites the operator has identified for development within the next 5 years for which it has not yet submitted applications for OGCC permits.
So the 5-year requirement, just to stop there, that is required by the Common Gas Conservation Commission right now. Any operator that comes to a municipality, and only municipality, not a county for some reason, but if they come to a municipality, they have to give you their 5-year plan, essentially. And so because that is already covered in state rules, I didn't add that. It certainly could be. Again, that's an example of something where the state has already covered it. They have to comply with the state. The state tells them that they have to share their 5-year plans with the municipality. I'd expect that would happen.
Okay.
But we could add it for sure.
Okay. And this is more informational for Stephen, I think, as well. So well estimates provided as part of the operator registration must be made using reasonable business judgment based on information known to the operator as of the date of the registration. You want to respond to each of these, or?
Again, she's reading, that is taken from a code, but that code is just parroting what's already in Common Gas Conservation Commission rules.
Okay. And so what you're saying is that these items already being in the code don't need to be in our code?
Already be in the Common Gas Conservation Commission rules. I don't believe they need to be in the code, but we certainly could add them.
Okay. And you have this list, Stephen, right?
I don't have it in front of me,
But you have
I've received
the
it,
comments
yeah.
from Lisa. Okay. All right.
I think her last question was outside.
Yeah, the last one, when considering the buffer, yeah, and this, I had a little concern around this too, but when considering the buffer from residential lots, can we consider residential lots from beyond our jurisdiction? So like Louisville, Boulder County, and yeah. So, and if so, it appears there's no eligible property in Superior with proper zoning or distance from residential lots. So wanted confirmation on that. We think that's true. And if so, does this leave the town at risk by an operator asking for a location waiver because there is no reasonable ability to develop within the town? That being, their waiver reason.
So, sure. they could ask, they could say, we absolutely have to develop within the town of Superior, and we need to be closer than 1,000 feet away from a home. And at that point, what the regulations require is that before they get, into being able to get a waiver, they have to do an alternative location analysis, and they have to prove to your planning staff that indeed that is the case, that the only place they could possibly develop these minerals is from in the city, in the town limits. And honestly,
But it could also be to get.
everything to the west and all sorts of locations, even as far as, again, 3 miles away, could access minerals within the town of Superior. There are multiple locations that would be far better and wouldn't require a waiver of anybody's setback rights.
But if they wanted to put the well in Superior in order to get to, outside of Superior, right, into Louisville, or.
Could they do that?
They could, right? I mean, that.
And vice versa. Again.
I'm sorry, repeat that?
And vice versa. They
Yeah.
could go from Louisville and
No,
try to get
well,
into
we know they can
Superior.
go into Superior, but I mean, if they want to
Right.
build, I mean, part of the waiver request could be they're trying to get somewhere in Louisville, right? And there's a place
Right.
in Superior that's,
So what this comes down to is the one area that you can't regulate is downhole issues. You have to take the application at its, at its face. What are they trying to do on the surface? And determining, you can certainly look at alternative locations. If they're trying to get to, say, these minerals here, is there a location outside of the town of Superior? What are all of the locations that they can use to access that? And we would ask them to come up with as many locations as there are. And there may be one location within the town of Superior. Maybe the majority of those locations are outside of the town of Superior. And so, if they were trying to access minerals in Louisville, we would have to ask them, is that the only place that you could possibly access those minerals from? And if they said yes, you still have to go through this criteria for a location waiver, that protection of public health, safety, and welfare are served to a greater extent by a waiver than strict adherence to the location requirements. If you feel that it's harmful, that you need the 1,000-foot setback, and it would be harmful to have anything closer than that to your residents, the town trustees can say no.
okay.
And I expect that, if there's not that many places, frankly, within the town of Superior that oil and gas could be developed safely. And with the zoning and the setbacks, it would be very difficult to find a location.
Are any of these new regulations being litigated, or are they likely to be litigated by the oil and gas community in the near future?
Well, I think that probably the pretty easy answer is yes. There are questions that were left open by Senate Bill 181. The biggest question hanging out there is, what does it mean to be reasonable and necessary to protect public health and safety? That is something that, there are definitions, and there have been cases that look at what is the definition of reasonable, what's the definition of necessary, but that combination applied to the oil and gas industry, that hasn't been litigated and probably will be. I don't believe that these regulations will be challenged, because I don't believe that there's a huge line of oil and gas companies that are trying to get into the town. And frankly, this is very similar to what has already been passed by Adams County and is currently working for Adams County and for operators. Adams County has a 1,000-foot setback from platted residential lots, and they still have oil and gas development. They still have pending applications and new applications coming in all the time, working through their new process. Our process is not that different. Again, I would argue that it is very reasonable and necessary for the town of Superior and would withstand any challenge.
Is this process closing out small companies?
I think generally we're seeing requirements by the state and by local governments requiring a greater commitment of resources. As an example, you know, the idea of having additional financial assurance or requiring a pipeline, you know, then you're getting into scale. There are pipeline, there are midstream companies all over the place that can provide to a ma and pa oil and gas operator. But particularly when you're talking about something in Superior, there's not a lot of infrastructure nearby. That would be a real commitment of resources to get an oil pipeline to have takeaway from the town of Superior. And you're right. I think that that's more likely going to be taken on by, you know, one of the larger operators. Having said that, you know, none of us here in this room can guess what oil prices are going to do tomorrow, let alone, you know, in 10 years. And, you know, if oil prices go through the roof, it may very well be worth it to the oil and gas industry to provide that type of infrastructure. And it might be quite easy to do that even for a smaller operator.
What is, how is oil and gas regulated on Boulder County open space at the moment?
We are still in moratorium.
Okay.
Yeah.
Is there any hints of where they'll be going with that?
You know, I know that they have a moratorium that is expiring around the same time that the town of Superior's moratorium is expiring. So I am expecting to hear from the county staff anytime as to what that might look like. It's difficult because the county, unlike the town of Superior, has plenty of open space in areas that they would say, you know, could be done safely to public health and safety, but it's not, you know, protective of the environment. And if they're having to choose, is it going to go on private property or is it going to go on public property? I think, you know, if you're refusing any access to you know, that public open space and pushing it onto private property and closer to homes, that's problematic. I don't think anybody wants to see that. So I don't know where they're going to land.
What about the
it'll be interesting to see.
multi-jurisdictional open space? I mean, we have open space that's often owned by 2 or 3 two municipalities in a county, for example. Do you know how that?
It would be jurisdictional. So I guess I can let you answer, but my guess would be that if it's jurisdictional. So we, you know, you see our boundary. If that open space falls within our boundary, then it's going to be our regulations because that's in our zone district. And then if it's outside our boundary within Boulder County, unincorporated Boulder County, it would be the county's responsibility.
And if it's city and county, if it's city of Boulder and county owned?
City of Boulder and county owned.
Because they have shared.
I think it's the same thing.
They have shared open space as well.
It's in the city of Boulder's jurisdiction. If not, it defaults to the county.
Okay, so if it's not within the city limits of Boulder.
Correct.
Defines
Is that
it.
correct?
Yeah. So it gets only slightly more complicated. Certainly, the regulations are going to be whatever jurisdiction it's in. So it could be wholly owned by Boulder County, but be within the town limits of Superior. You still get to regulate it. However, if they're trying to put oil and gas facility on that open space, they have to work through a surface use agreement, and that's a private contract with the operator or between the operator and the property owner, the surface property owner. And so that's also an opportunity for there to be additional requirements or for the property owner to say no, that we're not interested in allowing it. That is still you know, yet another threshold question as to, you know, is there space, adequate space, and does the property owner even want that oil and gas development?
And part of what I think Lisa alluded to too is, I mean, we have Boulder County open space bordering our jurisdiction. So is our residential lots, I mean, it is a cross jurisdiction, right? So, I mean, can they put something on county open space 200 feet away from
in relation to
a residential lot, right?
So that is a big issue and a big question. Currently, the Oil and Gas Conservation Commission only allows the jurisdiction that has it on within their boundaries to have standing before the Colorado Oil and Gas Conservation Commission to challenge an oil and gas location. So if they were to be 5 feet outside of of the town of Superior, you have to then go kind of hat in hand and say to Boulder County, say, you know, that's a little close, and we're hoping that you're going to protect our constituents, and we don't want to see it there, we want to see it farther away. And that's Boulder County's decision. It's not yours at all. Even though it's 7 feet away, you don't have jurisdiction over that because it's outside of your town boundaries.
I thought you said that was in the state regulations as well.
Right, but the state regulations, at the current state regulations, only give you standing to challenge if you are the jurisdiction, the jurisdiction that has it within their boundaries. They call it the relevant local government. However, one of the proposed changes, and one of the things that I think that the town of Superior really needs to follow, is that they're giving standing. The Colorado Gas Conservation Commission is proposing to give standing to adjacent local governments that are within 2,000 feet of a proposal. So it's 2,000 feet, it's in Broomfield, it's, you know, still close enough to affect your interests. You can challenge that before the Colorado Gas Conservation Commission. You can't regulate it yourself, it's outside of your jurisdiction, but there's the other decision maker being the state. You can challenge it before that state body. And so that would be a huge improvement to avoid having something located immediately outside your jurisdiction in Jefferson County, as an example.
So Stephen, it would seem that, I mean, with us being in Boulder County, we have some influence on the Boulder County side, and at least being in communication with Boulder County to make sure that they're protecting the interests, which I'm sure they would want to, within the cities, within their jurisdiction, right? I mean.
Yeah, I mean, I have not been able to keep up with what Boulder County is doing, but I did used to work there before I came here, and I can just, you know, say that Boulder County, you know, devotes more resources to this than most jurisdictions, and they have dedicated staff that are all about and almost exclusively about oil and gas. And
It just seems like we ought to be
Right.
well aware of what they're doing to protect the municipalities within the, you know, within their county, right? Because Broomfield, we have less control over, right? I mean, if that, then it becomes state, right? So if somebody wants to get under Superior, they want to go 5 feet into Broomfield, and there's a space there, and they can sit right outside town, we got to go to the state if we're concerned about it. If this even is put in the rule, as part of the rules, right? Which it isn't at this point. But within the county, it would seem like municipalities ought to be talking to the county to make sure that, you know, that there would be no way that they would even consider putting a well 100 feet inside the county, you know, off the borders of any of their towns or cities, right?
Correct.
You know,
But Boulder County, in my estimation and in my experience, does everything they can to prohibit it.
I would agree.
So,
I just
yeah.
think
But no,
we need to be, you know, we should all be, all the cities should be paying attention to that. I would think.
Shouldn't this be a regional council, what would they call it, the Regional Council of Governments?
Well, that's regional. I don't know if that's
Well,
county. It's not county.
No, but it includes all of the local
regional
governments,
council.
doesn't it? No? What's it, I forgot.
Yeah,
Drawing
I don't know
a
whether
blank.
that's a jurisdiction, though. I mean, a county's a jurisdiction.
Yeah, but I mean, it ought to be a sort of, I mean, it would be nice if there was an intergovernmental agreement that all the towns were going to protect each other from that kind. If it goes through the state, fine. If it doesn't.
Well, we could
it
do
would
that at
be
the
nice.
county. That's what I'm suggesting. We could do that at the county level,
Yeah.
right? That could be part of county regulation. I would think they could build that in. But but then as soon as you get outside of that, I mean, we border Broomfield, you know, your parts of Lafayette border Weld County, right?
Sure.
And there are other counties, so then we are looking at the state.
Well, unless we had an agreement with Louisville, an agreement with, I mean, there ought to be a regional, it would be nice if there was a regional agreement among the local governments to,
I agree, but the
Cooperate.
county jurisdiction exists, so the county should, I would think the county, because they're an existing regulatory body,
I see.
could do it, right? They could just do it for the entire county and work with all the cities and towns to do this, but then
Well,
outside of that, it's going to the state. You're suggesting yet another one,
well, no,
but
I'm guessing, what I didn't know, maybe I should just ask. Superior is in Boulder County, for instance, right? So the Superior adopts one set of regulations and the county adopts another set of regulations. Whose regulations govern?
Yeah, wherever that location is
Right.
proposed. So
Yeah,
if
so-
it's located just outside of the town of Superior in Boulder County gets to make those decisions. But to your point, Boulder County is also looking at their own regulations.
Sure.
And their regulations could say that within 2,000 feet, you know, we will consider or strongly consider the setbacks that are required by that local municipality.
Or it could be more aggressive if the cities
Or it
within the
could be
county
more.
push them to do that, right? That's why I was just
there's-
suggesting we stay involved.
I think that staying involved or keeping apprised of what's happening in Boulder County, and frankly, keeping apprised of what's happening in the Common Gas Conservation Commission is in your interest.
Yeah.
Because, you know, you have a relationship with Boulder County, but Jefferson County, you know, doesn't
Agreed.
have much of a track record on oil and gas.
Right.
It just hasn't been that much oil and gas.
And that
But it's
state,
immediately to your
Right,
south.
exactly.
Broomfield has a track record with oil and gas, and, you know, they're, you know, struggling with oil and gas right now. What would they say if it was going to be away from their constituents, but immediately adjacent to yours?
Right.
You know, there is a possibility of an intergovernmental agreement. That takes a long time to
Does,
negotiate, and, you know, we are, a number of local governments are meeting with one another and keeping each other apprised of different regulations that they're looking at, and they're certainly going to know about the regulations that you pass here within the next couple of
Yeah.
months.
Well, I think I remember the mayor of Broomfield coming here
That's right.
on one occasion and actually, well, I think you were here too, and actually saying, we'll help you, basically. You know, we'll tell you we'll tell you what's going on with Broomfield so that you can avoid having it happen here. So, I mean, there seemed to be some interest in mutual assistance around this issue.
I think that's right.
I think that's all. Let's see what Lisa had. There are a few more bullet points, but I think he was saying these are right out of the OGCC.
I believe so, yeah.
Any other comments, questions? Thank you.
Thank
That
you.
was awesome to get that update. Appreciate it. You don't need anything from us, Stephen?
Thank you.
Thanks, Matt. Just if you wanted to give an update on the 2020 work plan and your presentation or your discussion
Yeah, I
with the
meant
board.
in regards to this.
Oh, in
item,
regard
yeah.
to this item?
Yeah.
Other than, you know, that the board is going to consider this and adopting the proposed regulations and the ordinance on March 9th. So if you guys have, you know, any comments you want to relate to them, we can do that. Or you're welcome to go to that meeting and do that as well. So, but yeah, I don't have anything else on that one. It is an interesting and complicated discussion item.
Yeah.
If I can make a comment to Commissioner Harper's comments about having an, you know, intergovernmental relationship with Broomfield, with, you know, it's a county, Jefferson County, you know, Weld County out there on the other side of Lafayette, to, you know, share information, to let each other know what's coming down the pipe, so to speak, with, you know, relation to the oil and gas industry and these permits that are coming through. I've been on the map looking at around Superior. There's a fair amount of abandoned wells, dry and abandoned wells, and plugged and abandoned wells. But I did find one well that's producing, and it's 1.15 miles away from the town of Superior. It's right at where 470 or where the Northwest Parkway ends. And so from that location, they could drill underneath the town of Superior. Again, like Mr. Sura said, that we don't have any control over the subsurface, which is, you know, they could put a well outside, a mile or two outside,
Right.
and still drill underneath us. That's very disturbing. So it's a very convoluted, confusing topic.
All right, should we move on to the work plan? Okay. Let's see, so I emailed everyone, but I did meet with Mayor Folsom and kind of expressed the concerns I had about meeting with the board. He assured me, as did Martin, that if we need to meet with the board, he looks at the planning commission as a different type of body, we're a quasi judicial body and not an advisory committee. And, you know, if we've got to meet with the board, they'll, you know, he agreed they'd make that happen. So that was good. He also was very interested in ADUs, and it sounds like the board is as well, just based on the feedback we got from the plan and working with the community. That stayed on the work plan, yeah.
Is that still understood to be ADUs in original town or ADUs all over
Well,
Superior?
it would be ADUs in the town of Superior, correct, Stephen? This wouldn't be, I mean, you wouldn't regulate this to a neighborhood, or
That's a good question. I mean, I think that is a good question for the board, because the discussion has been framed thus far as for
Yeah.
original town.
That
within
was my,
standard zoning, yeah.
because HOAs are not.
yeah,
they're
the
not gonna
HOA
permit it,
covenants
right?
would,
That's-
yeah,
right. So we'd have to define the neighborhood, I guess, then too, and then would that include the new development that's happening in town? What, what are the borders of original town exactly, and what isn't original anymore, right? So.
I mean,
Well, it
just,
does, yeah.
I keep going back to Rock Creek has by far the largest lots, and the most possibility to do ADUs.
Yep.
But if, you can't affect the Rock Creek, PUD, whatever it is.
Yeah.
It's a lot of work for a very minimal impact on original town.
And the HOA would never go for it, I doubt, but I don't know, maybe. So,
Yeah, I don't
That
know
would
what
be
their
an uphill
desire
battle.
is, but that would be, yeah.
well, I'd say I was hoping to at least touch base on ADUs. Let me hit the rest of the work plan that was approved. They approved our work plan with some minor changes. So the things that we're responsible for, reviewing and commenting on development projects, stayed the same on same capital. We review and comment on major capital improvement projects. Regarding the Northwest Superior planning project action items is how it's listed. The ADUs, they'd like us to work on that, but beyond that, especially Trustee Ryan didn't want us to spend too much time on any other part of the Northwest area plan, short of working with staff as appropriate, as things might come up, in the marketplace. So, the comprehensive plan, we're looking at the 2021 budget process. So does that mean for 2021 or budgeting in 2021 for 2022? Do you know what
You'd
they?
be budgeting for the work next year. So we have to have that, the budget for 2021 starts to be discussed.
Coming up in August or so
Well,
this
even
year.
before, yeah, the beginning of the
Before.
summer.
Okay.
Yep, so.
All right. So we would plan to do a comprehensive plan update. It'd be pretty targeted, of course, because there's not a whole lot.
I think it's a good idea.
Yeah. All right. And then as time allows, and per staff for commissioner recommendations, schedule work sessions to evaluate the land use code and related ordinances, provide recommendations to the town board as appropriate. So as we have time and want to work on that, as things that are on our mind and we want to look at them more closely, we can. If Stephen has things related to code that need cleanup, we can work on those as well.
And that's kind of another, I mean, I guess I'm not clear necessarily on what, planning commission's role in the land use code is clear. It says that you guys can look at that and
Whenever
make
we want,
changes or
yeah.
whatever. It's not as clear as to, like, you can't go and look at the Rock Creek PUD or downtown. I don't know, it's still zoning, it's just different zoning, but I think that you would need like that HOA or whatever to kind of come and say, and maybe when we look at the ADUs, we'd look at some sort of path that could be adopted, by, the minimum lot size and, that type of stuff, if, or they just end up looking at it and being like, oh, that's nice, how do we get that allowance? You mentioned it for Sagamore, right? So,
So the HOA would have to, how would Sagamore work? Because
we would have to have an amendment to the PUD for each one in order to allow it, if it's specifically prohibited. I'm not sure that Rock Creek necessarily prohibits it, but I don't think that their HOA necessarily.
But the HOA would
supports
have
it.
to,
Yeah.
their board would
Right.
have to approve it. What would happen in Sagamore? Because that's town, they're the same as
That's
original town now.
Yeah, I
There's no
would think that
HOA
they
in
would just need
place.
to come forward, but I don't know, that's what's tricky once you have, that's what's so much easier to adopt or make changes to PD, before you have a bunch of residents in place, because once you do, we have to go through these hoops to say that, we had to add notes to the PD for downtown that clarified that it only affected the blocks that hadn't been developed and the blocks that were changing, because we have residents on block 13 and block 25 that aren't part of that application yet, and we didn't make any changes to anything that affects them except for what their downtown's gonna be, you know,
Right.
so like, but, so it is just, it becomes more complicated, so.
Okay. All right.
But, yeah, I don't know how we would need, like, probably the HOA would need to, be the applicant for something like that is how I imagine it.
Okay. And the last two items, provide input on affordable housing initiatives undertaken by the town. That was tweaked, so that we wouldn't be driving it, but we would just comment as things arose. And then, or just keep informed about regional planning with adjacent jurisdictions, which is left in there. So, and that was
Which
approved at the last board.
Similar to
meeting.
what you guys are talking about with oil and gas stuff, so.
Yeah.
I think that's just, yeah.
So with regards to ADUs, since that seems to be the one item that there's a desire for us to work on, any thoughts on how to proceed? I mean, we can, when we have meetings where we don't have anything before us, we can use that time, right, to meet,
Right,
work on
discuss it,
ADUs.
yeah.
I'd encourage us to do that and try to get this done. I don't know, you give us some guidance as to how big of an effort this might be for you and for us. Do you have any thoughts?
Yeah, we have some codes that, we've gotten to a certain point,
Yeah.
over the summer, or last summer, I should say, in this discussion, but it is, and I don't know whether or not we just make some suggestions based on, what's standard, like there's typically a size limit and, there's some regulations that talk about owner occupancy, so you don't just have somebody own a property and rent out two properties now versus like actually, because like it's the same thing for like if you have a short-term rental, people feel like you have, if you're just renting out a room in your house or a room above your garage or something like that, and you actually live on site, it's less impactful than if somebody just rents out a whole house and they don't even live in the jurisdiction because of noise issues and those type of things, so.
There was a workshop that the mayor attended, I know,
Oh, yeah?
on this, recently, and we talked about it. There's a book that he gave me. I've seen that book before. I'll email it to all of you in case you want to get your hands on it and take a look at it. They were really touting a lot less regulation,
Right.
not requiring owner occupancy, not putting restrictions on parking, just to allow, and that allows the, the neighborhood to just develop a different
Right.
way
So
that seems to work, but
Right.
I'd like to read the book and, get an idea of it.
Well, and that's where some direction on, before we go too far down the road, it wouldn't hurt to have some better direction from the board or like,
Yeah.
what they're looking at. Because you either, like the jurisdictions I worked in that have it, they either are concerned about so many, and it's usually not a viable, or a legitimate concern. It's like you regulate it so that you don't have 1,000 the first year, or,
Right.
you don't make it too easy. You require, a separate water tap or something, so that's actually almost cost prohibitive to do it. So I think that the direction, at least your guys' sentiment, is that we don't want to make it too prohibitive. We want to actually encourage these to the extent possible. But the other kind of trick is that we don't have any, like, where the beauty was in the design guideline changes and actually updating, like, and adopting something, is you could have somebody come in and put, a metal building in their backyard that doesn't have any,
Right.
continuity with the front of their actual primary residence. Because we don't have any regulations for the primary residence, so you can't really adopt regulations for the ADU, like in terms of what it looks like aesthetically. So that's what's, we're working without a full, box of tools here. Because we didn't get those design guidelines, approved for original town. So I think we have fewer regulations to work with, but that's also kind of the direction that the board gave, was that we didn't want to provide a bunch of different development standards for this area of town. So maybe we keep it super simple, super loose, and then present them something and then get feedback. If they need us to change it, then we go from there.
And our code has some regulate, I mean, you
Right,
can't
it's
put a
not-
metal building on the dirt, right? I mean, you.
Right. No, you have to, right. But
yeah.
it's just like I'm talking about the aesthetics.
The aesthetic look, yeah.
Or actually even having the same materials or look or whatever,
Yeah.
kind of finished architecture.
Well, and a big part of it too is, a lot of this is going on in town already, right?
Right.
And it's, yeah,
But if you're going to
yeah.
if you're going to give somebody an allowance they don't have, I think that the perception from the board was we didn't want to start curbing people's development allowances or like taking things away. So if ADUs aren't allowed now and everything is, like, everything that gets granted is a give rather than any kind of constraint, I think you have a little bit more latitude to say, you know, you don't necessarily want an ADU that's bigger than the primary residence. You know, so maybe there is a percentage that you say, you know, if.
But you might have that in this town.
You
And
could.
that's a difficult thing, right? Because some of these homes are
Small.
722 square
appropriate
feet,
to have?
right?
So those are the
You
kind of
you build a
conversations
garage
we
and put an
need to
apartment
have.
on top, and it's bigger than the house, right?
Right.
Well, and then the house becomes the ADU.
Well, there you go.
The original house is the ADU, yeah.
That's right. Yeah, so, yeah, so we do have some work ahead of us
Yeah.
to kind of think through how this is going to work.
And along the lines of the ADUs, I know several properties around Rock Creek that are walkout styled houses where the basement has been made into an apartment completely. Some of them have been for family members, aging family members that have moved into with younger parts of their family. Other residences have been rented out as short-term rentals through VRBO. Some of them have been rented out long-term to CU students, things like that. They've been there for years.
Right. So if you have regulations that allow them, we tend to get those building permits submitted to us, you know, like much more than if you don't have regulations that allow them, then that stuff happens. And generally it's unpermitted, or they'll permit a certain percentage of it. You know, that's actually where they get to without putting a separate kitchen in or whatever. Because you can have a bedroom and a bathroom and separate entrance, you know,
Yeah,
no one
right.
prohibits you from
Absolutely.
having a walkout basement or whatever. But, you know, it's, and how it's used, you know, it becomes a second residence typically when you have the kitchen. So, I mean, that's the threshold that kind of pushes somebody over, so.
Yeah.
Gotcha. Thank you.
That's
So
critical.
maybe-
Yeah, sorry, I didn't see it. So, but yeah, we can start having those conversations again, and maybe we just have like a work session, kind of refresher as to where we
Yeah.
left off, and then.
Yeah, I'd ask our
Go from
the next slot, whether we have a light agenda or whether we have nothing for a particular meeting. Are you guys okay if we just plan a work session on this? And I'll get this book copy out to you guys, and
Yeah,
I'll
absolutely.
try to find out what the board's thinking. I mean, just because, I don't know whether they're thinking the way the mayor was, his interest, certainly was probably a little less regulation than more regulation. And let me rephrase that. That's what was discussed at the workshop, right? How it applies to our town and whether it works is that's, I guess, up to us to figure out. But, maybe this book could be a good place for all of us to start.
There was some strong interest from the original town residents about ADUs,
Yeah.
so yeah. we should look into
Yeah, I
it
think
more.
everybody's interested, and like I said, I think there's a bunch of them out there, and got them in Rock Creek too, and whether the HOA would entertain it, that's a big discussion, do we make this town-wide and then permit other jurisdictions? And town-wide meaning whatever falls underneath land use code for the town.
Right.
Which is gonna be outside the PDs, but then these other jurisdictions, can look at whether they wanna come forward and make adjustments for their development plans. Right, so. And I don't know how you do that in Sagamore. I have no idea. They just all get together and ask the town to do it, or
Yeah, we have to.
who's responsible for the PD?
We don't have an HOA.
You
No,
know,
but you have a
HOA.
PD.
Yeah. I don't know how it happened. It's an interesting question.
Yeah.
I'm not even sure it's prohibited, so, I
Yeah.
haven't looked at the PD
I
in
think
general.
I studied it because I was like, oh, can I put a shed in my yard? It seems pretty quiet on it. Other than that, the setbacks just make anything
Right.
pretty much
Yeah,
impossible.
true.
So, but that's the thing, so like typically when you have a PD that's silent on something, it defaults to the code and we have no avenue. So
Right.
that's just something that we have no avenue for an ADU within the code, and once we do, I think the jurisdictions that don't explicitly prohibit it would have an
Therefore,
avenue to have them
to allow
too.
it.
So we could look at it either way, it's just a matter of, I'd want legal counsel as to how we,
But I think
and that
it's,
type of thing.
if, other than the basement ones, yeah, I think that could happen in Sagamore for sure. But yeah, an accessory dwelling unit, I don't think there's any way to build one.
But ADUs do include basement. That would include a basement apartment, or is that still an accessory dwelling unit, or no? Like an
Yeah, I
apartment
guess
above
it
a
could be.
garage,
I
or
mean, yeah.
do we just have
Would
to
it-
define
So
it?
that's what's tricky,
Yeah,
like, is
require
how
its
we
own
want to
entrance,
define it.
entrance and
Right,
exit.
what are the requirements for it? Yeah, does it have to have its own entrance?
Right. I mean, that's all how it gets defined right now. We don't have a
Whereas basement,
definition.
Yeah,
So-
if it's totally underground, there is no separate entrance.
Well, it's,
But somebody
someone has done it. There's, you enter the main entrance and then there's the door, a door to the basement and a
Yep,
door
Yeah,
to the rest of the house.
Yeah, there you go. Well, somebody in Old Town dug it out and they put an entrance in the basement, so, yeah.
Well, and that's what's tricky too, is that becomes, I mean, you have a fine line between that being a duplex, because that's technically what
Sure.
it is. It's the same building. So I think
Well,
it's
yeah.
like a true accessory dwelling unit is accessory to the primary structure and
Yeah.
probably separate, in most cases.
Well, and that's what they did over in the, the 5 new homes across from PetSmart there. Those are all, so that some of them are 10 grand away from a duplex. I mean, there's even it's a kitchen that's not a kitchen yet. It's
Right.
10 grand away from a duplex. It's basically this private entrance, a wall to separate it off and turn the bar into a kitchen, and it's done, right? So
Right.
we'd have to decide whether we want to permit that or not, right?
Yeah.
And some direction from the board. I mean, if they want more residents in the area, they're trying to,
But and some of the things we need to talk through are like the parking. So that's one of those
Right.
impacts that just, like, once you have, one, family unit living on a property, you're kind of expecting, 2 to 3 cars. If you allow us accessory
2.
dwelling,
you're gonna have 4 or
you
5.
typically,
6.
I mean, like, we need to discuss whether or not, if it's a certain size, then it's probably going to accommodate a certain amount of people. If it's unlimited size, then it could accommodate another family.
Yeah.
And then, if it's 1 person or 2 people, then maybe that's 1 car. If you want that parking space to be on the site too, rather than having a bunch of more cars on the street, which could have an impact. And those are the things that kind of like once you start getting into all the nuances of it, that's what kind of scares municipalities
Sure.
and makes it more tempered,
Yeah.
just because you want to control something, you want to control the unknowns rather than just kind of leave it open-ended, so.
Yeah.
But it'll be an interesting discussion.
Sure. Okay. All right. So yeah, if you get that on the next open slot, that'd be great.
I think that there's nothing actually I think the next development review meeting, I have my calendar up, will be the 17th of March. So the meeting on the 3rd would be available for a work session
Okay.
entirely if you guys.
I'll go home and get that email out tonight for
Okay.
the book and out to everybody. We'll just see where we are on the 3rd and,
Okay, I'll touch base with you the week before.
okay.
Or-
What's coming up on the 17th?
We're targeting, I think, the Zaharias application coming to planning commission if they
Oh, wow.
resubmit on time. So
Sorry, the who?
the Zaharias application, so that's the one that's,
88.
yeah, on the
Okay.
east side of 88, just south of US 36. So,
Townhomes and
apartments.
apartments.
Yeah.
Okay. So it changed.
I think it's always been apartments.
Was it? Okay.
Yeah,
I thought it was
so-
townhomes.
It's been a long review process for that one.
Yes,
so.
yeah.
Are they really starting to build at Autry Shores?
Oh, Superior Shores,
Yeah.
Autry Shores.
Sorry, is it called Superior Shores?
Resolution.
My understanding is they have a new partner for that. So, and I think that new partner wants to come in at some point and subdivide and not do condos and actually do townhomes. So we'll have to have a plat application in order to create those lots and likely an FDP amendment to establish setback standards and stuff, things that we didn't address because we didn't have lot lines previously. So before that happens, I expect that application, and we've talked to them a couple of times, and I haven't got an application yet, so I don't know when that's happening. But
Anything else?
Are we talking about March 3rd as a next meeting?
Yeah, sorry, March 3rd, next meeting.
Are we going to be able to get into the parking lot with it being election day?
oh,
Yeah, it is.
is that?
I think that's what it is, isn't
It
it?
is, yes.
Yeah.
No,
It's just a ballot, right? Like the,
it's a mail-in, yeah. But yes,
Still
parking.
vote on election day?
I already voted.
don't wait till the
Yeah.
third. Yeah.
We'll just have to watch out when, I'll park at your house and
There
walk
you go.
down to the
There you go.
Come on.
We'll meet at Bob's house.
If you guys feel like that's enough time, then we can have that meeting. If you guys want more time to think about ADUs or whatever, we can push it to another meeting.
We'll see where we get. We can put feelers out.
I mean, I recognize that ADUs are a practical issue that we can actually address, but I'm disappointed that we're not doing a little more on the Northwest Marketplace and on the regional planning things, because if I think about what's important to the long-term future of Superior, I think the Northwest Marketplace and what Louisville does across the street are probably going to have more impact.
Yeah, the way that was discussed is that the work that we did instigated a lot of activity on Brixmor and interest in the town, and that it's kind of in their court, and so they weren't interested in actively trying to make that happen. Kind of the impression that I got. So I think as Brixmor, RTD, and others come forward that will be receptive for it, or receptive to it. We've thought a lot about it. We have a lot of ideas on paper, I guess is probably the best way to put it, that we can react and respond because we've thought about it. But yeah, I would have loved to see something more proactive happen, but it's not going to. So, the regional planning, on the other hand, I mean, this has been on our that statement's been on our work plan
for a couple of years, at least, yeah.
And we can go as far as,
I mean, I'd really like to know where Louisville stands with whatever it is they're planning to do over there. I mean, I saw...
Well, there's a meeting tonight. You could just jump out of here and run over there and find out what's going on with Medtronics. Yep, they're, yep, I don't know, yeah.
I think, yeah, go ahead.
Yeah, no, yeah. Do you know more?
I just think that what's on the agenda for tonight is financial related, whether or not they approve a metro district or some sort of
Yeah, it was a
financing
metro
for
district
it. Yeah,
thing.
so.
Yeah. Well, we can have a joint session. We've had joint sessions with their planning board.
I don't know a lot about it, but for instance, I saw they were planning, one idea for what goes in over by Coles was a liquor store. It didn't strike me as very favorable to Superior liquor. Didn't even strike me as particularly useful for the population in the area.
Yep.
It would seem to be, I mean, they in Louisville and we in Superior may feel that there's some difference in crossing the bridge, but I doubt people driving from Boulder or Bloomfield feel the same way.
Yeah, and whether that level of joint planning, I'd be shocked if that went very far. I mean, if they want to, they're going to put in there what they, I mean, the market's going to drive what gets put over there.
It would be nice to know just what it is, for instance.
Yeah. Well, Lisa's she's in planning over there. I said, I'm now the president of the Louisville Chamber, so I'm hearing some more things, not quite at the level that staff is, but I'll try to communicate whatever I hear as it's happening. I know that building was, I believe, acquired by Ascent Church. They were originally planning to build their church over on 95th and Dillon, but abandoned that. They broke ground. It was land acquired and permits approved and ground broken, and then something happened, and I don't know the details.
They wanted to build it right next to a space where a Catholic church was going to get built as well.
It was like 90, I don't know. But I know they ended up buying that building and are making plans to do things there. And there's a lot of interest in that whole McCaslin area from a business perspective, from the various committees, the downtown, or not downtown, but the chamber of the town, I think maybe even Brad, that McCaslin area is of big interest, right? They have a lot that needs to be redeveloped, and there's interest in engaging those businesses and, making sure they know they're part of Louisville, because a lot of attention gets put to downtown and less seems to get put to that area, so. But we can engage their planning commission if we want. I think I've done that once. Had a joint meeting, I think, with their planning board.
It was before me.
Years ago.
But,
Yeah, you weren't here. But it was neat. It gave us a chance to all, talk with each other about.
I think it would be, it's not like it's a long way away.
No.
Mostly these days, if I want to go to the movie theater, I just walk across the bridge.
Exactly.
Could be.
And they all come to Costco. So.
Yeah, exactly.
All right. Any staff announcements, Stephen, before we?
No.
Okay.
Not other than what we've already discussed.
All right.
So.
Anybody have anything else? Yeah. Good. All right. We're adjourned.